Welcome everyone to the book launch for the Routledge Handbook for Financial Technology and the Law. My name is Chiu. I'm director of the UCL Centre for Ethics and Law, and we are the hosts of this event today. We are very pleased to be introducing this handbook to you, also because I'm co-editor of this handbook with Professor Gudula Deipenbrock, who is one of the panelist speakers today. I'll say a little bit about the handbook, so that your appetite can be whetted before you hear the panelists introduce their chapters. This handbook contains 24 chapters, and we provide a high-level perspective as well as an up-to-date commentary on various sectors where fintech has been deployed and has seen great success. We deal with the lending sector, the payment sector, the investment services sector, markets and trading, as well as regulatory compliance. And we also have a few chapters devoted to the area of crypto finance that many people are interested in. I'll briefly say a few words about how we'll run this event today. So today's running order will be that the panel will speak first. So I'll be introducing each panelist. And I'll do that at the beginning of the session so that each panelist can then have a seamless time to join in the delivery of their presentations. Each panelist will speak for about 10 minutes. And after the panel has concluded, we'll then address questions from the audience. So during the panel event, members of the audience, please feel free to submit your questions through the Q&A function. I'll be monitoring this throughout the event. And if we have many questions, then I will be bunching them together according to theme to address to the panelists at the end of the panel. However, if there are not that many questions, then we hope to be able to have time to have each question that is submitted answered by the relevant panelist. Dr. Matteo Solinas, one of our panelists, has joined us at a very unearthly hour in New Zealand, and he will be leaving us after the presentation. And so we do welcome questions for him during his talk, and we will also be addressing any specific questions to him at the conclusion of his presentation. So let me now briefly introduce our panelists for the day. We are very privileged to have with us our distinguished contributors to the book, a selection of them, as we'll have another launch event at a later date in summer with another slate of our contributors. So today with us, first to speak will be Professor Gudula Deipenbrock, my co-editor. Professor Deipenbrock is a distinguished commentator in comparative business law. She's at HTW Berlin, and she's published extensively on business and financial law and has a special interest in fintech. So Professor Deipenbrock's full biography is available on our event registration website. Following from Professor Deipenbrock, we have Dr. Matteo Solinas, who joins us from New Zealand. Dr. Solinas is senior lecturer at the Victoria University of Wellington, and Matteo has done a lot of work in relation to blockchain technology, as well as trading markets. And this is the area that he has written for us in this book. And we hope that he will share his insights and give you a summary taste of what it is that he has prepared for us. Following from that, we have Professor Saula Omarova, who is Beth and Mark Goldberg Professor of Law at Cornell University. Professor Omarova has also written extensively on the law and policy of fintech, and you'll be regaled by her slides as well as her chapter. Following from that, we have Professor Florian Merslein from the Philipps University Marburg. Professor Merslein is himself a very prolific writer in fintech and has edited a large handbook in Germany as well. So we're very privileged to have him join our book. And finally, we have Dr. Jason Allen, who is Senior Research Fellow at the Humboldt University, Berlin, as well as visiting lecturer at University of Tasmania in Australia. Jason has done extensive research on the nature of crypto assets and is an expert on the private law aspects especially. So Jason will be talking to us about his contribution to the handbook. I will now call on Professor Saula Omarova to provide us with her presentation. Saula's chapter closely follows Gudula's chapter, and this is the order of the presentations that we have determined to be most appropriate in this panel. Over to you, Saula.
Thank you very much. First of all, let me begin by saying how honored I am to participate in today's panel, but also to be one of the contributors to this wonderful volume. It really is an incredible collection of very interesting, very diverse perspectives on a highly complicated, complex issue. And I'm also glad that Matteo's presentation was it ended on this note of on an inquiry, right? Should crypto assets be regulated as securities, for example? And as the answer to that question indicates, it's actually not so simple. And this is the kind of a question that really permeates the entirety of all of these discussions in law and policy about, regulatory status of the new fintech products that are sort of like familiar financial products and yet not quite like them. Are they tech products? Are they financial products? Where do they fit? And this was the question that really prompted my interest in the topic that became the subject of my chapter, the contribution to this volume. And so without further ado, let me share the screen, share with you my feeble attempt at a PowerPoint. So here we go. The problem that I'm trying to address here is this, let's step back and think about how fintech is disrupting not any specific scheme of or regime of financial regulation, like, for example, securities regulation, banking regulation, commodities regulation, so on and so forth, but the entirety of financial regulation as an enterprise. In other words, there is something more fundamental to the paradigm of financial regulation as we know it currently, that fintech and the rise of cryptography, the rise of big data analytics, and so on and so forth, really put at a limit of their capacity. So that takes us to a question of what is the model, the current model of financial regulation. And in this chapter, I call the current model of financial regulation a technocratic model. And it's a particular sort of concept that I try to develop here. What does that mean? Of course, every jurisdiction has its own specific approach to how to regulate financial sector and financial services. But in general, all of the modern regulatory systems sort of based on a principle of structurally segmenting the approach among different product types or entity types. So even if, for example, in some jurisdictions, we may have a single regulatory agency overseeing all types of financial products and services, nevertheless, even within that one agency, there is a substantively different approach to regulating securities, vis-a-vis, for example, regulating the banking sector, right? Banks are regulated very differently from securities firms, for example, insurers. And that means that bureaucratic expertise becomes very specific to a particular type of regulatory structure, regulatory scheme, right? And securities lawyers, for example, rarely would ever, get into issues affecting banks, pure banks, for instance. More interestingly, this scheme of financial regulation is based on the concept that it is possible and necessary to identify certain specific market failures within those specific segments of the financial markets and technically precisely target those market failures and define those regulatory problems in certain very granular terms, micro terms, rather than macro terms. In fact, that is a sign, at least in the United States, this is sort of a telltale sign of a quote unquote good regulator or an effective, efficient regulator to be able to zero in at the most micro level specific issue that needs to be addressed with a scalpel rather than taking an axe to it, right? If you cannot manipulate the scalpel, you are considered some kind of a stupid regulator, or dumb regulator, if I may say so. And there is also an accompanying preference for very measurable, normatively neutral solutions and outcomes. And what's interesting about it, that model has worked for several decades, but fintech is pushing it to its limits. Why is it doing so? So the chapter is looking at 5 basic ways how fintech is changing the financial system. And here, let me just make a clarification here. Of course, we all know how fintech is changing the way we individually can transact in the financial space. In other words, we know that now we don't have to go to the brick and mortar bank or banking branch to withdraw physical cash in order to pay for our coffee at Starbucks, right? We can do all of it on the phone if you have an app, right? And soon we may not even have to use euros or US dollars. Actually, now at US Starbucks, you don't even have to use those, I think. I don't do that, but my students do. They have some fancy Starbucks points of some kind, which of course is money, right? It's like a certain type of private money to pay for their coffee. But what we don't really think about in everyday everyday thinking activities is what fintech is doing to the system of finance on a more kind of macro level. So let's step back and think about it. First of all, new technology makes finance bigger, right? It brings in, first of all, it opens the menu of financial choices and services, but it also brings in new providers. And it also, at least ostensibly, allows new segments of the population that previously were not able maybe to participate in financial activities, now to participate in financial activities because they can do it cheaper and faster. Fintech is making finance faster. That's the whole point of fintech, right? Otherwise, why would we need that? Fintech is making finance more technocentric. So Matteo's point about this sort of trustless trust is the key to that. The narrative is that we don't need trust, we don't need power anymore. Everything is neutral, everything is basically encoded in a scientific product, which is a particular software. And that software determines what happens on what conditions, right? So it's all about technology now. It's really not about power. It's not about policy. It's not about politics. The fourth change is that fintech is making finance more opaque and complex. By definition, if you outsource a lot of the decision to complicated algorithms, then it's very, very difficult then for untrained people like myself, for example, to understand what exactly is happening, who is supporting that code, who is providing that algorithm, what changes are being put in there without my understanding of what's going on. It's more complex at the same time as it is less complex in some sense to transact. It's more complex in terms of what's happening behind the scenes. And finally, it's making finance more fluid. It's blurring boundaries. It's not just boundaries among different jurisdictions, it's boundaries among different financial products. So what does it mean from the perspective of the existing model of financial regulation? There are 5 challenges that map on to those 5 structural changes that fintech is bringing on. The scale and scope challenge is pretty self-explanatory, right? It's if the world of finance is bigger and more diverse, right, then it means that financial regulators now have to deal with a much larger regulatory perimeter. It's very hard to police the boundaries. Who's inside the banking sector? Who are the providers of banking services? If the services can now be provided on a phone app by some Silicon Valley startup, for example, as opposed to JP Morgan, the bank, right? And the regulators have to deal with how to deal with this much more diverse universe of providers. Also, whom do we protect now and against what risks? It's very difficult for the system that is meant to kind of segment everything and put everything in neat boxes now to deal with this much bigger, much more diverse universe. The speed velocity challenge is quite interesting. Frictionless, fast, instantaneous financial transactions for all of us on individual level, right? When we can make payments, micro payments in milliseconds is great for us, right? But on a systemic level, that means that, for example, financial speculation, that quote unquote really bad thing in financial markets, also can happen instantaneously. It also becomes frictionless. It also becomes cheap to engage in. And if it's cheap and fast and easy, then what stops hedge funds, for example, and other big institutional speculators from upping their game to a point where the regulators now have to deal with the fact that now the system is prone to much faster and much more violent shocks that can stem from that excessive speculation. And if that's the case, how do you react to that? If you are the central bank, for example, the Federal Reserve, sitting at the center of the huge financial market, right? And you start seeing that a cascade of, for example, fall in prices of certain financial assets is happening in milliseconds, how fast can you react to set up a liquidity provision facility, for example, right? That in the United States takes weeks to set up, right? When the market is moving so fast. The trust and power challenge. It is naive at best to say that just because algorithm now makes decisions, there is no quote unquote trust, there is no power in the financial markets. Of course there is power. Money is power, right? And the challenge for the regulators now becomes to understand the new sources of this new type of power, right? Where does it reside? And that's extremely difficult. And it's also important then to bring in the political norms into it. Is it good that, for example, a bunch of coders now can move tremendous amounts of money in financial markets without even really people understanding, that they're moving that? Transparency and governability challenge is about capacity limits. What does it mean for regulators? Does it mean that they all have to get PhDs in computer science? Does it mean that they have now, to stop relying simply on disclosure? Because just disclosing the volumes of data and transactions to regulators doesn't really get you to all of this understanding of the inner dynamics of algorithmic finance. So that's a big challenge. And finally, boundary challenge. That's the biggest of all. And Jason Allen, my esteemed colleague here on this panel, has written extensively on that from a very philosophical perspective. It's an incredible challenge, not only in terms of the fact that different jurisdictions have to come together and cooperate, but also it's extremely important now to figure out what is where financial sector ends and the tech sector begins, especially with the big tech companies like Facebook and Amazon and Google entering into the world of financial services. Where does the jurisdiction of the financial regulator really then ends? Should now the Federal Reserve, for example, oversee Facebook? And I'm sure that people at the Federal Reserve will not be too happy about that prospect, right? So what does it all mean? This is, of course, a set of big questions, lots of research ahead of all of us, and I'm hoping that lots of people will do that research. But at a very broad level, my chapter basically leaves us with this. The borderless and frictionless finance demands borderless and frictionless oversight. We have to overcome this old, really segmented, structured, bureaucratically expertized, politically neutral notion of regulation. We cannot deal with it. It just doesn't fit. The glove doesn't fit the hand anymore, right? We need more open-ended and flexible jurisdictional and regulatory authority. How do we do it? I don't know, but that's what we need. We also need to emphasize more explicitly structural solutions. It's not about behavior. It's not about trying to, after the fact, figure out who defrauded whom. We have to make sure that the structure of the financial market is such that certain frictionless fraud cannot happen. Otherwise, after the fact, we may not really remedy its bad consequences. And finally, we need to really more explicitly integrate financial regulation into the broader economic policy making, perhaps to introduce the normative priorities back into the technocratic regulatory mindset. In effect, we basically need an attitudinal shift. And this is a very important point, and I'm going to end on it. Currently, the regulators are basically just chasing after technology. The name of the game right now is to just not to let things go out of hand too much, just chase and chase and chase. And everybody who knows anything about, finance knows that, if you're constantly in the reactive mode, you've lost the game. In the world of finance, you cannot be in that reactive passive mode. You have to be ahead of time. So from accommodating, the regulators need to shift gears into the proactive shaping of financial markets, technology-driven financial markets, so that those financial markets actually serve public interest rather than private interest alone. Thank you very much.
Thank you very much, Saula, always for your thought-provoking perspectives. I mean, we have a lot of unfinished work in terms of both structural responses on regulators' side as well as substantive responses. This is a call to the audience to keep your questions coming because they will be addressed at the Q&A session. Before that, we will call upon Professor Florian Möslein to give us his presentation. Florian, please.
Thank you, Iris. Thanks a lot for inviting me and for having me today. This is a book launch, so I take the chance to show the book for the first time. Since you won't see it, but it is here. Thank you so much for having me and for having me in the book and on the panel today. I really appreciate collaborating with you, and I even more appreciate to read in the book. Now, my chapter is chapter 2. It forms part of the general overreaching introductory part, and therefore it might also require some explanation, not only as to its content, but also some explanation how it really fits into the book. I prepared some slides which I would like to share with you. The title of my chapter is Smart Contracts and Civil Law Challenges, Does Legal Origins Theory Apply? Now, you might wonder how this chapter, how this title, how this idea fits to financial technology and law. So therefore, I want to explain that before I briefly tell you something about the content, not too much, because I hope that some of you read the chapter afterwards. Now, what are smart contracts? Smart contracts are often considered to be the central building block of the blockchain economy, but also of the fintech universe. Why is that so? Well, I copied some pages or some articles from The Economist. Smart contracts promise to change the economy more than any other feature of the blockchain. That really shows all the expectations and all the hype that really is made about smart contracts. Why are they relevant? In what sense are they relevant? In particular for financial services? Well, that is a question that has already been discussed 5 years ago. For instance, in a study by Capgemini, getting from hype to reality. Well, actually, I think it still is some sort of hype today, but already 5 years ago, there have been many use cases, both in investment banking, in retail banking, and also in the insurance sector. Examples like insurance contracts where you can automate the operation of this contract by using smart contracts. And on the slide, you see the expectations, how much money could be saved by using smart contracts. Well, today, the focus has changed a bit. It has changed from individual financial transactions to markets. The hype today is about DeFi, decentralized finance, and that's becoming a huge market. The market capitalization is quite impressive. What is DeFi? Well, the idea behind DeFi is to build an alternative financial infrastructure on the basis of distributed ledger technologies. And the relevance of smart contracts in that context is that DeFi really uses smart contracts to create protocols that replicate existing financial services in a more open, interoperable, and transparent way. So what is happening here is the construction of a whole alternative infrastructure to the traditional conception of financial markets, an infrastructure that is built on smart contracts. And that shows the importance of smart contracts as building blocks of this ecosystem. Now, that does not yet explain what a smart contract is, and that does not yet explain the notion of smart contracts. Now, the person who is among those who have invented the word, Vitalik Buterin, is not very happy about his own wording. To be clear, he wrote in this Twitter tweet, to be clear, at this point, I quite regret adopting the term smart contracts. I should have called them something more boring and technical, perhaps something like persistent scripts. Well, it is too late. It is too late. Everybody uses the word, and the word as such has already some attraction to it, it seems. What is the idea behind smart contract? Well, the smart contract operates as some sort of regulatory technology. It's a functional equivalent to traditional contracts, but also to traditional contract law. It builds contracts, but on the basis of technology. It's a technology-based form of exchange. There are various definitions around, and Nick Szabo, another leading figure in the field, has used himself various different definitions. A computerized transaction protocol that executes the terms of a contract. A second definition he uses is a set of promises specified in digital form, including protocols with which the parties perform on these promises. And then he speaks about a machine programmed with rules that could have been defined in a contract. Instead, the machine performs or verifies performance. Well, this last definition shows that smart contracts are not something that can exclusively build on distributed ledger technologies, but that the traditional vending machine, as you see on this slide, can also be understood as some form of smart contract. It's a machine that helps to execute contracts. You will only get the bottle of Coke if you throw money into the machine, and therefore the execution of that contract is executed or is enabled by that vending machine. However, blockchain technology, distributed ledger technologies facilitate this form of machine-enabled contracting to a large extent because they are decentralized, because they operate on a worldwide basis, and because they do not require parties to be at the same place at the same time. Now, the key features of smart contracts are that they allow the technical formulation, the formulation of rules and sanctions for agreements into technology, and that they allow for automatic enforcement of these promises. Now, not every smart contract is a contract in the legal sense. Even if called a contract, it is another question whether in the legal sense it does qualify as a contract. And as a consequence, the relationship between these technology-based smart contracts on the one hand and contract law on the other hand is very subtle. It is true that smart contracts are somehow embedded in contract law, because smart contracts can be qualified as contracts in the legal sense, but still, at the same time, they are kind of alternative, a functional equivalent to traditional legal contracts. And therefore, both worlds, the digital world and the legal world, compete with each other, interact with each other, and somehow also cooperate with each other. The challenge, therefore, is to find out how smart contracts fit into legal systems and what features of a given contract law system enable smart contracts, which types of legal systems are suitable for smart contracts. And that brings me to the questions of my own chapter. The question is, does legal origins theory apply? Now, what I try to do in the chapter is to bring these technological developments together with a very old, very well-known theory, legal origins theory. And this theory argues on the basis of the divide of civil law and common law. It argues that there's a difference between both systems of law. It argues that the system of law, whether codified or whether common law, has an impact on economic outcomes. And the main argument is that civil law contains stricter regulations on the one hand and less efficient contract enforcement on the other hand. Now, what I'm doing in the chapter is to consider whether some sort of legal origins theory 2.0 applies, namely whether the divide between these two different sorts of legal systems has an impact on smart contracts, on the use of smart contracts under these systems of law. And that turns out to be somehow paradoxical, because on the one hand, you might argue that there might be a higher demand for smart contracts in civil law systems because smart contracts allow for an efficient technological enforcement. And the argument of Laporta and others was that civil legal systems don't allow for efficient enforcement, and therefore smart contracts might help to cure this deficit. On the other hand, one might argue that smart contracts are less easily accommodated in civil law system because the original argument was that civil law system contain stricter regulations, and therefore the freedom for smart contracts, the freedom to adopt smart contracts might be smaller than in common law systems. So the question is, what is this true? Is this claim of legal origins true? Is it really applicable to the digital world? Well, if you look at it, and I skipped the part of the arguments that I bring in the chapter, but you can read them afterwards. But the conclusion that I'm drawing is that it is very difficult to foresee and to predict which legal system will be more efficient, more suitable to accommodate smart contracts. The race is still open. It is too close to call. But at least the example of German law shows that there is, in fact, quite a high degree of contractual freedom. And therefore, there is very much room to use smart contracts. Even on a constitutional basis, there is a constitutional guarantee to take advantage of these forms of transactions. And therefore, I draw the conclusion that the legal origins 2.0 theory can be falsified. Civil law systems can be, and in fact are, well prepared to accommodate this technological development. They follow a balanced approach as to their legal validity and also as to the contractual interpretation of smart contracts. And therefore, civil law systems, I propose, are not necessarily less smart contract friendly than the common law counterparts. Thank you very much for your attention, and I very much look forward to the Q&A session.
Thank you. Thank you very much, Florian, for your very insightful presentation. And I think it would be the case that, as Saula has mentioned, fintech cuts across so many boundaries that even the traditional boundaries of civil and common law systems are likely to be challenged with this, by this phenomenon. Right. I'm glad that many questions are coming in, and hopefully our panelists will be prepared. You can check out the questions on the Q&A section. Right. I will now call on our final panelist, Dr. Jason Allen, to talk to us about his chapter. One of the questions that was raised in the Q&A earlier is that someone is very interested in the property law concepts regarding crypto assets and whether that could provide basically, a private law self-regulating system without any further regulatory policy. So perhaps you might want to address that as well in your presentation. Over to you, Jason.
Thank you very much, Iris. And again, I'd like to echo, the comments of the speakers who have gone before me. It's been wonderful to be involved in this handbook. And thank you very much also for the invitation to present tonight and also to the other speakers. I'll just share my screen, which is always, this is always a sensitive moment for someone who calls himself a lawyer working on digital technology, but it seems that we have liftoff. So I'll seal off tonight's panel with some comments, and actually I'm really glad that I've gone last, because I think this follows on very well from many of the previous presentations. Definitely Florian's and Matteo's in particular. This chapter is on crypto assets in private law, and I think this is a question that has become a lot more, if not urgent. I think it's a question which is a lot more obvious now than it was a couple of years ago, or even when this project was initiated. And in this chapter, I really try to take quite a general and a comparative sort of approach, noticing some of these differences between civil law and common law systems, for example, without weighing in on the question, which is sort of relatively better on the merits, but noticing some fairly broad level differences. The common law has this concept of property, which tends to be a little bit more open textured, whereas some of the civil law systems, including systems like German, Polish, Japanese law, have they adopt an axiomatic definition of what can and can't be a thing, and therefore an object of the right of ownership, right up in the general part of the civil code, and that necessitates a different route of accommodation of purely digital objects. So it's an expressly comparative kind of a chapter, which also means I can't go into too much detail in the chapter because every legal system has its own peculiarities, and my focus is more at the general level. It's also avowedly on private law. And again, for the first few years that we non-technical people were aware of the phenomena unfolding in the wake of that 2008 Bitcoin white paper. A lot of the focus was on regulation, and a lot of our understanding and early efforts to taxonomize these new sort of financial instruments or financial assets were also regulatory driven. And so this trichotomy of payment, security, and utility tokens was really characteristic of a lot of the early thought leadership and reports by organizations and scholars and so forth. I'm not so interested in that in this chapter. I'm interested in the private law treatment of crypto assets. And sort of the premise is a bit of a disjunction between law that regulates and private law that sort of enables and provides building blocks to parties to engage in legal transactions themselves. So the chapter has really two main aims. First, it's to get towards a basic categorization of digital assets, and particularly these novel digital assets that we've seen, with the growth of distributed ledger technology. And the point of that categorization, it's not just a taxonomic exercise or a philosophical exercise, it's also to see how they can be integrated without too much friction into the normal mechanics that private law gives to parties to do things like transferring property or making wills or gifts or declaring trusts or starting companies or whatever the case may be. Starting companies in the sense of contributing capital rather than starting companies in the sense of registering a new legal entity. That's getting into regulatory law. So the second aim of the chapter is therefore to introduce and give an overview of some of the kinds of private law issues and to start to organize and sort of classify the different types of private law issues that are arising and are even more likely to arise in the future. So the chapter proceeds, and really it has three sort of substantive parts. The first looks at the definition of crypto assets and other digital assets, and rejects this regulatory driven sort of trichotomy of payment security and utility tokens. The second explores under a number of headings the way that crypto assets can be objects of legal verbs. And I look particularly at verbs like owning, holding, transferring, and encumbering. These are things that we like to do with assets, with the things that we hold or own. And then briefly, I touch on the smart contract question, which Florian has really capably dealt with. Now, a caveat for this chapter as a whole. Following the definition, which I will discuss momentarily, the chapter focuses on crypto assets as I define them narrowly. And it doesn't explore some of the very important and pressing and very interesting issues about digital assets that may be based on DLT, but that represent off-chain value. So the chapter makes an intentionally limited contribution, but I think that is the absolutely crucial starting point. And my experience on a couple of bodies now, an UNITOIR project on the private law applicable to digital assets, and an UNCITRAL project on emerging technologies and law, have really vindicated this intuition of mine that it's important in the first instance to define these new phenomena that have arisen, since 2008, because only on that basis can we start to tease out, what problems do and don't arise and what we do and don't have to actually answer. There's a number of confounding factors in looking at the private law applicable to digital assets. I mean, one is the obvious one. We have pretty major systemic differences between private law systems around the world. This is something which I've got a particular sensitivity to at the moment. I'm 25 pages away from translating, 450 pages of a text that compares all of the property law systems of the European Union, then still including the UK and therefore England and Wales. And there really is a lot of difference, not only in the content of property law, but also in the systemic structure of property law systems and how we think about things like property. And property, of course, is a cornerstone of private law generally and is of particular importance here. Second is that in virtually all legal systems, actually, I would say categorically, in all legal systems at the moment, we've got a more or less unsatisfactory treatment of incorporeal objects. There's insufficient clarity in English law, which is one of the most open, as to how concepts like possession apply to incorporeal objects. We have a weird ancient or early modern, at least, taxonomy in English law where we have incorporeal hereditaments, which count as if they were land. But then on the other hand, we have, documentary intangibles, which count as if they were chattels. And really, we don't have legal systems that are well tailored to incorporeal objects because, when those legal systems evolved historically, they were preoccupied with with land and physical property. You know, and then obviously in the codified systems, we have systems, you know, like Germany saying, well, things are corporeal, basta, period. And that means that in order to deal with incorporeal objects really fully, to do them justice, we need to come up with workarounds that circumvent this, but therefore, in my opinion, somewhat undermine the, I suppose, systemic integrity of the system or of the codification that chose to proceed on the basis of an axiomatic definition of things. And there's the danger that these workarounds will proliferate, and then, you know, it looks a little bit like English plumbing. So another confounding factor is that we've got this constant tension between property on obligations, and this is general in commercial law. I've noticed in a lot of discussions, we like to think that parties can, by agreement, sort of create a subject matter of a contract which they treat as if it were a thing, but is it really a thing? And are we here concerned with the law of property or the law of obligational relationships? We've got, you know, the problem which I've already mentioned, that we need to adapt basic concepts and mechanisms to fit incorporeal objects. And then something that I don't even go into in the chapter because it's a problem of itself. We've got, you know, these cross-border phenomena. We've got the fact that the internet and DLT, you know, are really global and delocalizing technologies. And so, you know, we have interesting problems, not just of regulation, but also international private law to find out what law actually governs an asset or a contract. So I adopt in this chapter a very narrow definition of crypto assets as distinct from digital assets more generally, as a subset of digital assets more generally. And this is one that me and my colleagues at the Cambridge Centre for Alternative Finance have been sort of pushing since about 2018, 2019. And we think that it's a good starting point to just make sure that we don't get any wires crossed. And really, we say crypto assets are only your things like Bitcoin, which are internal to an open and permissionless distributed ledger technology system, which play an indispensable role in the design of the ledger itself. And this is because, you know, it's not a crucial difference on this view, whether, you know, a token uses conventional technology or digital ledger technology, whether it exists, whether a company share exists in an Excel spreadsheet or on a distributed ledger. A company share is a company share. And what we are interested in when we're talking about crypto assets is things that don't represent rights against counterparties, or at least don't clearly represent rights against clearly identifiable counterparties, or that don't represent rights in things that exist somehow off-chain. These other categories of digital assets, whether they use DLT or not, I argue in the chapter, are more readily brought within traditional categories of the law, such as res in corporalis, or such as shows as in action. There might be, you know, some difficulties in tweaking them in. They might need to be shoehorned a little bit. We might need to adjust those categories. But the problem is not as fundamental as with a Bitcoin, where you say, well, what party do I have a right against, or what thing do I have a right in? So the next sections of the paper look at crypto assets narrowly defined as the objects of various legal verbs. We like to say that we own things. I'd like to think that I own my Bitcoin. I'd like to think that I can hold it, that I can transfer it to you, or that I can encumber it with something like a trust or a pledge or a usufruct or some sort of other security interest. And in all of these, I use more illustrative than exhaustive sort of examples from the legal systems that I'm most familiar with. And this is really in the spirit of you know, sketching out the sort of issues which both comparative lawyers like myself and national law experts are going to have to address. So, you know, obviously owning crypto assets, that was a question in the Q&A, which is a very good question. it's not equally straightforward in all jurisdictions. In English law, we've got a pretty clear statement from the High Court now saying, yes, crypto assets, can be property. In New Zealand, can be property for, the limited purposes of being the subject matter of a trust. In jurisdictions like Liechtenstein and Germany, we've seen law reform efforts where, again, we're making a workaround. In Germany, for example, it's been proposed, and I'm not sure of the status of the proposal, where we say, well, we'll say that bitcoins, or not bitcoins, but we'll say that electronic securities in the language of the Act, they can't be things under Section 90 of the Civil Code, but we'll treat them as if they were. We'll deem them to be things, and therefore all of these other legal consequences, such as the right, that it can be owned, will follow. So my conclusion there is this is not a major hurdle in any legal system, but we do have a bit of legwork to do before we arrive at a satisfactory position of legal certainty. And that's only more important, now that the capitalization of some of these markets have just ballooned, and now they're a little bit more reasonable, but there's a lot of people who want to know that they own their bitcoins, I'll put it that way. The same with holding crypto assets. We tend to say that we hold something because, our public key is associated with a certain amount of unspent transaction value, for example, on the ledger. We are assuming that there are legal consequences from the state of a technological artifact being an information repository. And we should be, interested to ensure that that assumption is sound. The same with transferring, and the same with encumbering. In closing now, we see some references sometimes in the literature to this idea of the law of the horse, and saying, the law, property in cyberspace, that's just the law of the horse. What we need to do is develop general principles of property law. I think this is a very sensible idea. We don't want a proliferation of niche sub-disciplines within the law that then don't speak to each other. But I think I'd say respectfully, that Judge Easterbrook, to whom this is mostly attributed, had an opportunity in the mid-1990s to start talking about property in cyberspace. And he sort of talked about Xeroxes and photocopiers. And I think that a lot of the work that we're doing now could have probably been started quite some years ago. There is, I think, a need to engage, directly and consciously with the way that property rules operate in cyberspace in the context of sophisticated digital communications networks. And I think that's evident in the fact that, we've got dozens of experts working, diligently in some fantastic projects, including those I've mentioned under Uni3 and Ancestral. I really don't think that we're talking about the law of the horse, at least I hope not. I think, the next steps, I think hopefully we'll see some consolidation and mainstreaming after the current hype. And I think that one of the next theoretic priorities will be, addressing this area that I haven't touched on in this paper, or in this chapter, sorry, at all, which is really exploring and establishing a law around digital assets which do attempt to represent off-chain value, be that real estate or rights against the party, or rights in some sort of physical thing like gold or a commodity. So thank you very much, and I'll stop sharing my screen now.
Right, thank you very much, Jason, for your presentation, and very, very fascinating and insightful again on the various concepts of property law and how and the limitations that we are facing with regard to our traditional boundaries. So I guess it's probably 2 minutes to finish, and it gives me great pleasure again to thank you all, my panelist speakers, for joining us today from all different parts of the world. And honestly, I'm the only one with my administrator based in the UK. So thank you again for making this time, for contributing to the book. Gudula and I really enjoyed working with all of you, and really were delighted reading your contributions and putting this book together. So many thanks, and thank you to the audience who have been with us from the beginning. And we certainly hope that you'll find this to be a valuable and useful resource. So thank you very much, and all take care.